Welcome, welcome, welcome to the Southwest ADA Center at ILRU. Our training today is Know the ADA 504 framework that will lead to engaging, educating, and resolving student classroom accommodations issues in higher education. This is recorded for the CW Austin Virtual Learning Disabilities Conference from February 26th to March 5th, 2022. I'm your presenter today, Julie Ballinger with the Southwest ADA Center. And there, as you can see on the PowerPoint, is my contact information of 505-797-8612. My email is juliedballinger@outlook.com. Before we jump in and get started, let me just introduce myself. For over 32 years, I've worked in the disability rights field, providing leadership, innovative endeavors, technical assistance, and training. I directed a Center for Independent Living, which CILs are community-based nonprofits that provide empowering services to people with various disabilities and are designed and operated by people with disabilities. I have also worked for the University of Arkansas in providing technical assistance to CILs in 2 federal regions. As a Southwest ADA Center affiliate, my work includes ADA in-depth training, technical assistance, ADA best practice approaches, and disability awareness issues concerning employment, state and local government, obligations, and businesses' nonprofit access requirements. I want to thank Marissa DeMaya, Deputy Director of the Southwest ADA Center, who is recording this session and making this training possible. Before I jump to the content, I'm going to very quickly read the following. The information herein is intended solely as informal guidance and is neither a determination of legal rights or responsibilities under the Act or any other law, nor binding on any agency with enforcement responsibilities under the ADA or any other law. Next slide. So let me tell you about us at the Southwest ADA Center. We are part of the National ADA Network. There are 10 regional ADA centers throughout the nation. We at the Southwest ADA Center, we serve New Mexico, Texas, Arkansas, Louisiana, and Oklahoma. Each regional ADA center focuses on its own regional unique needs. So to find your regional ADA center, simply go to adata.org, or you can certainly call the 800 number and you will get your regional center at 800-949-4232. Next slide. The Americans with Disabilities Act. The Act is powerful in its simplicity. It will ensure that people with disabilities are given the basic guarantees for which they have worked so hard: independence, freedom of choice, control of their lives, and the opportunity to blend fully and equally into the rich mosaic of the American mainstream. This is by our first President Bush, President George H.W. Bush, at the signing of the Americans with Disabilities Act of 1990. Next slide. Before I jump into the content, I want to talk about the Southwest ADA Center publication that I authored along with the contributing author of Melanie Thornton, who is also a Southwest ADA Center affiliate. It's called Conversations with Faculty, Assessing Student Accommodation and Accommodation Denial in Higher Education. This publication is absolutely available to you, and please share it with anyone and everyone. This guide will give potential and present students, advocates, and higher education professionals an organized, straightforward tool to use when engaging, educating, and resolving issues with faculty or departments regarding academic disability-related accommodations. The link to the guide's there, but because this is a video, it might be easier for you simply to go to our website at southwestada.org and just do a search, Conversations with Faculty. Hope that you'll check it out. Next. So our training objective today, it's going to sound a little familiar because it mirrors that of Conversations with Faculty. But today I'm going to give students, advocates, and higher education disability resource professionals an organized, straightforward tool to use when, again, engaging, educating, or resolving issues with departments and faculty regarding academic disability-related accommodations. Now, please note that parents will be able to utilize this training to educate and prepare their maturing teenager with a disability to navigate the higher education setting regarding classroom accommodations. Next. So let's start with the law. Let's start with US federal legislation about higher education. Section 504 of the Rehabilitation Act of 1973. What this simply says that if an entity, including higher education institutions, if they receive federal funding, that entity cannot discriminate on the basis of disability. Also, regarding the ADA, Title II. Title II is state and local government services to the public. It's their ADA access obligations. And Title III, which is businesses and nonprofits, access obligations. Title III is also known as public accommodations. So let's talk about Title II. Higher education institutes that receive funding or are part, for example, of a state like the University of New Mexico, they must provide program access, meaning higher education programs must be accessible to and usable by people with various disabilities, including learning online programs. Regarding private colleges, now we're talking about private colleges that receive no government funding. They must follow ADA Title III obligations, which tend to not be as stringent as Title II obligations. Keep in mind, if these private colleges do receive government funding of any kind, whether it's state funding, local government funding, federal funding, then they must carry out that government's ADA requirements or Section 504 requirements. Just a side note, the Fair Housing Act, Section 504, and the ADA can apply to campus housing. Next. This is really interesting, and I want to share this with you. If you're familiar with the ADA Amendments Act, what the ADA Amendments Act was all about was to correct quite a few of the US Supreme Court rulings in terms of who is covered, who can seek protection under the ADA. So the Amendments Act was addressing that, was to bring the ADA back to its original intent of who can seek protection. Now, that really was the intent of the Amendments Act, but this was added to the Amendments Act. It's Title V, the American with Disabilities Act of 1990 is amended by adding at the end of Section 501 the following: fundamental alteration. Nothing in this act alters provision of Section 302B2A2, specifying that reasonable modifications in policies, practices, or procedures shall be required unless An entity can demonstrate that making such modifications in policies, practices, or procedures, including academic requirements in post-secondary education, would fundamentally alter the nature of the goods, services, facilities, privileges, advantage, or accommodations involved. So higher ed was specifically mentioned in this amendment. Next slide. So an academic adjustment or accommodation can only be denied if it can be shown that it will either fundamentally alter the class, requirements, or programs, give the student an unfair advantage over other students. In other words, it exceeds equal access, or it results in an undue burden. So what does all this mean? What is that about? Let's go to the next slide. First, let's address state and local government funded colleges. They have the term that they have in terms of an undue burden. It's called undue financial and administrative burden. So what does that mean when a university claims this, to where they say, we can't provide this classroom accommodation because it's an undue financial and administrative burden? States and local governments, in determining whether a particular aid or service would result in undue burdens, the Title II entity should take into consideration the cost of the particular aid or service in light of all resources available to fund the program, service, activity, and the effect on other expenses or operations. So in other words, they're not, a court is not going to look at, let's say, the Department of Psychology's budget. They're going to look at the total university's budget in terms of the claim of an undue financial and administrative burden. The decision that a particular aid or service would result in an undue burden must be made by a high-level official, no lower than a department head, and must include a written statement of the reasons for reaching that conclusion. The college also does not have to fundamentally alter the class, the requirement, or the program. But having said all that, the Title II entity, or in this case, the higher education institution, they must do what they can up to the point of fundamental alteration or undue burden. So an example would be if you're going to a state university and they're telling a student that they cannot afford American Sign Language interpreters, therefore that's not what they're going to do in terms of effective communication for a student. You can see all the steps they have to go through to justify they really can't because it's an undue financial and administrative burden. Next. So let's talk about private colleges, fundamental alteration and undue burden. Again, we are talking about for-profit or nonprofit public accommodations that don't receive any government funding. Because remember earlier that if these private colleges receive any kind of government funding, and many private colleges do in some form or another, they have to carry out that government's access obligations under the ADA and Section 504. So under a private college that doesn't receive any government funding, there's a term called undue burden. And interestingly enough, it's only specific to Title III effective communication. Effective communication is the provision of ASL interpreters. It may be captioning of videos. It could be alternative formats such as Braille or large print, etc. The public accommodation does not have to furnish any communication aids or services that place an undue burden on the entity. An undue burden is defined as significant difficulty or expense and is evaluated on a case-by-case basis relative to public accommodation or the private college's overall resources. So note that when a particular communication or aid or service would cause an undue burden, the public accommodation must provide another communication aid or service that is as effective as possible, but less difficult or costly if one is available. The college also, just like Title II, public universities, the college does not have to fundamentally alter the class requirement or program. Again, just like Title II entities, the public accommodation or the private college must do what it can up to the point of fundamental alteration or undue burden. Next. So that's what I'm laying for you here is the groundwork to go into the next section of our training. I'm sure you all are familiar with the U.S. Department of Education, Office of Civil Rights. They're the folks that if you have a complaint regarding higher education, they're the folks that you file a complaint with, and I'll talk more about that later. So it is pretty important what they have to say about higher education. So engaging, educating, resolving issues, what OCR says is a college, a university should shift away from the approach where the Student Disability Services Office or student has the burden of convincing the particular academic department or instructor to provide the accommodation modification. Here's a quote from one of OCR's voluntary resolutions with a college. The ability of the Disabled Student Services Office to persuade an instructor or academic department to provide an adjustment, accommodation, should not be the determining factor in whether the student is accorded an accommodation to which she or he is entitled or they are entitled. So it's providing access for students with disabilities, including students with learning disabilities, is a very serious matter, according to the U.S. Department of Education, according to the Americans with Disabilities Act, and according to Section 504 of the Rehabilitation Act. Next. So let's actually now dive into classroom accommodations. Let's dive into assessing accommodations and accommodation denial. So a good practice is to start with this. If the student is having trouble getting the accommodation they need in a particular classroom, the student or the student's advocate, the student and or the advocate, or even Student Disability Access Office, if they're disagreeing with the instructor, what should be happening in terms of creating access in that classroom or that program, start with this conversation. Start with a conversation that helps the instructor or the department head understand the purpose of the accommodation and how that accommodation creates access. And because it's a two-way conversation, helps the disability service professional or student or advocate understand the nature of the course or exam and how the accommodation needs to fit within the specific context. So we are talking about opening a conversation and everybody hearing each other out. However, If a conflict still exists, next, OCR says, the Office of Civil Rights says, the college should have a clearly articulated written procedure. Now, before I jump into this, I think it is important to know that if you are assessing colleges, you're thinking about going to colleges, that these are the kind of questions to ask the potential college in terms of what they have, how they deal with student accommodations due to disability, etc. So the college should have clearly articulate written procedures for addressing such conflicts, including designation of an administrator with authority over the parties and responsibilities to resolve accommodation disputes, which is an effective method for ensuring institutional compliance with Section 504 and Title II. So the premise of a formal procedure is that the educational institution has a real obligation. I'm going to repeat that. The educational institution has a real obligation to seek suitable means of reasonably accommodating a disabled person and to submit a factual record indicating that it conscientiously carried out the statutory obligation. Next. Having said that, it's helpful, and OCR expects this effectively framing to academic departments. It involves helping the department or the instructor fully understand that a denial of an accommodation could mean a denial of civil rights, meaning that this is a very serious issue and that the instructor must be fully prepared to justify their decision to the student and even possibly justify their decision to the U.S. Department of Education, Office of Civil Rights, or be prepared to justify their decision to a student's lawyer. The instructor must take an active role of denial rather than a passive one of simply disagreeing with the college disability services or the student. So if there's a denial, is the denial defendable when it is weighed against what is expected under the ADA and Section 504 of the Rehabilitation Act? Next. So this brings us to assessing student accommodation and accommodation denial guide. Again, you can refer back to Conversations with Faculty. And even though the name of the publication on our website, at the Southwest ADA Center's website, is Conversations with Faculty, and it's slightly geared towards Student Disability Access Office, advocating actually on behalf of the student. This guide, this analysis can be done by anyone. It can be done by the student with the department, by the student with the instructor, professor, faculty, by an advocate, etc. So this is a breakdown of assessing accommodation and accommodation denial. So let's look at number one. What are the instructor's general class policies and process? And how does that affect equal access determination? Do these policies include how each individual disabled student's access needs are determined and met? Design with access in mind. That's really what this is about. This is a best practice for all higher education institutions, is that all the classes actually have policies and processes that go, oh, yep, we recognize that we will have students that access learning in different ways due to disability. It doesn't make that student a special student. It doesn't make their accommodation a special thing to do. All we really are acknowledging is that we are not always accessible to everyone. We are not accessible to students with various disabilities. So we're going to make sure that we are aware of that and that we have class policies and processes that make the way, that clear the path, clear the road to where we make sure that the student with a disability has barriers, learning barriers removed, so they can have equal opportunity in the higher education setting. If you're a higher education professional listening to this training, actually students can be very helpful in this, as well as all kinds of disability related organizations, including those of us at the Southwest ADA Center. Number 2, will or does the granted accommodation directly correlate with the student's disability or barriers? So, for example, if the student needs extra test time, how does that directly relate to their disability? That correlation must be made. 3, what is Student Disability Services recommending and why? Have these suggested accommodations or modifications been taken in consideration by the department or the instructor? A different angle on this question is, has Student Disability Services taken in consideration what the student is asking Disability Access Services to do? Next. Number 4, what the class is designed to do and measure should be carefully examined. What knowledge is the professor teaching? What activities are being used to determine and measure the student's understanding, implementation, and expression of gained knowledge? This is one of the core and heartbeats in terms of the conversation. What is the class designed to do and measure? Okay, then what activities are being used to do that? So, for example, what is the test truly measuring? And how does the requested accommodation affect or not affect this measurement? What happens here that we've seen happen in higher ed is that if that's not understood, and a student with a disability takes a test, for example, without removing disability-related barriers, then all that test is going to do is reflect back that student's disability. It's not going to give the information of the understanding, the implementation, and the expression of the knowledge gained by that student. That's why those barriers must be removed, so that the instructor can actually get to what that is that they are trying to assess, what they're trying to measure. So if you have a student who has a speech disabilities and it's an oral test, and the test has to be done in 20 minutes, well, clearly, there's a barrier in that 20 minutes, in that the student is not going to be able to orally express in 20 minutes everything they know about the subject that's being tested. So obviously removing that barrier so you actually get the measurement of the knowledge that you're seeking to get is that you expand the testing time, for example, to 30 minutes. So now you're not just measuring how quickly a student can get out and verbalize what it is they know. You're just now measuring what it is you really want to get, and that's the student's knowledge of the particular subject. Number 5. Does the requested accommodation lower the learning standards? Okay, if it does, it's very important that the department, the instructor is very clear exactly how that happens. What is happening there? If we do X accommodation, explain exactly how that accommodation itself, or what the student believes is barrier removal, how that accommodation lowers that learning standard. It's not a, well, I think the accommodation is going to lower the learning standard, therefore we're not going to do it. No, it has to be, this is how. This is exactly how this accommodation lowers the standard. Number 6. Does the requested accommodation fundamentally alter the class requirements? And if that's the case, be very detailed in how this is happening. Fundamentally altered. Okay, well, let's talk about that. How exactly is the provision of a particular accommodation fundamentally altering the class requirements? Now, here's the thing about this question, and actually all of the 10 questions. The more you dissect a situation, the more opportunities can arise to find a solution. Next. 7. Does the request give the student an unfair advantage over other students? If so, exactly how? So just notice here regarding an unfair advantage, it can't be that the accommodation gives the student equal access and removes barriers so they have equal opportunity, but that the accommodation actually exceeds equal access by giving an unfair edge. Number 8. Would the accommodation result in an undue financial or administrative burden? If so, be very specific how. Now, as we talked about earlier in the training, this is a pretty big deal to claim this. So remember, burden determination must involve the head of the college or his or her designee, after considering all resources available in funding and operation of the service, program, or activity, and it must be accompanied by a written statement of reasons for reaching that conclusion. And then, of course, the college has to do what they can up to the point of undue burden. So, for example, if the college is saying we can't provide the ASL interpreters, an example I used earlier, well, they can't just say, well, we can't afford it. This is a process. This is a big deal process in which the higher institution has to go through to actually show they really can't. They really can't afford an ASL interpreter. They really can't afford to do alternative formats for all kinds of materials, etc. And this is the process they must do to come to that conclusion. And as we, and I repeat myself, okay, then what can they do? What can they do to remove barriers? Next. Almost there. Number 9. What other equally effective accommodations can be considered and provided that will offer equal access for the student if the instructor or the department denies the requested accommodation? All right, so let's say that the conversation, the analysis 1 through 8 has happened. And it turns out, yes, the accommodation is going to fundamentally alter, it's going to give an unfair edge, it's going to be an undue burden. Okay, then what else? What else can be done to remove the disability-related barrier? Number 10. Does the appeal process afford immediate opportunity for the student to have their petition addressed in a timely manner in order to prevent irreparable harm to the student if their appeal prevails? This is so important. In terms of higher education, it moves forward. It stops for no one. You have classes. Classes don't stop meeting. It moves forward. Even during our pandemic, higher ed figure out how to move forward. So the appeal process has to match that pace. It has to match the pace that if the student believes that they should have had the accommodation, they were unjustly denied, that appeal process should move at a very quick rate, so that if the appeal process prevails, irreparable harm is not done to that student. Next. So remember again, an adjustment can only be denied if it can show that it will either fundamentally alters the class requirements or programs, give the student an unfair advantage over other students exceeding equal access, results in an undue burden. Next. Now, I'm going to talk about a few things that should come into play in terms of all the training and everything we're talking about. Essential program requirements. Okay, that's important because a college, a university does not have to fundamentally alter their essential requirements for a classroom, a program, a degree, etc. So it's important that before a decision that a class or program requirement is essential, the request should be carefully reviewed, adhering to specific procedural guidelines that includes debate about the nature and fundamental requirements of the particular class or program, subjecting it to a substantive review. In a way, yes, it's a challenge. This essential requirement, is it indeed really, truly essential? Next. Let's talk about class substitution. We know for many higher education institutions, they have an approach that's called a well-rounded education. A well-rounded education is not only do you take classes in your degree, but you take other classes outside your degree so that the institution produces what they call a well-rounded educated person. So consideration of class substitution or waiver should be taken into serious consideration, barring fundamental alteration, if no academic accommodation can be given. Let me give you an example here. A student who is a journalist, a journalist major, they want to be a newspaper person, they want to be a journalist. They have learning disabilities. Their learning disabilities happen to affect mathematics. Now, the college says, yes, you're a journalist major, we totally get that, but we're going to make you well-rounded in your education. So in addition to all of your classes in your major, you have to take other classes. You have to take a foreign language, you have to take some mathematics, you have to take. Can the college, if you have a student that their learning disability affects mathematics, when they take mathematics, and that there's no really good accommodations to remove the barriers that the student will face in taking their mathematics classes. Okay, college, what else can the student do? Can they take a different class to be well-rounded and not have to take mathematics? Or can that be waived, etc.? To me, and in terms of all the years that I've done this, it seems that really the goal here is to educate our society to the best of our ability. We know that an educated population is a population that can help us sustain our democracy, as well as to sustain our economy, etc. We're much better off with an educated population. So the idea of a college, a university, denying a student a journalist degree because the student has learning disabilities that shows up, that manifests in mathematics, and denying that student that degree because the student cannot pass a mathematics class, that is something to be challenged and thought through very thoroughly. You have a student who wants to be a journalist. I think the student can be a journalist and still have a well-rounded education, as long as the college can have a broad suite of courses to choose from that steer students, in addition to gaining their specified profession, to receive the well-rounded education. So the challenge there is some flexibility challenges to the higher education institution to define and redefine well-rounded education. Next. Future requirements. This is very important to understand. A denial of accommodation cannot be justified based on the instructor's personal doubts about the student's ability to meet future requirements of the degree or profession. It is the here and now. The student takes classes for, a student takes classes for many reasons. They may be taking the class not because they're actually going to pursue a complete degree, it's because they're just interested and they're taking the class. But the point here actually is, and OCR is clear about this, is that the denial or approval of accommodation should be based on the present class or program requirement only. So the instructor can say, well, okay, you'll do fine in this class with accommodations, but you still have to do a whole lot of other things to be a nurse. And by providing you these accommodations in this particular class, I don't know how you're going to complete this program. Can't do that. Denial or approval of accommodation should be based on the present class or program requirement only. And as the student advances in those nursing classes, then there's that class to look at and accommodations. Then there's the next class to look at and accommodations, and so on and so on. I just want to note that ahead, which I'm going to talk about in a minute, they have excellent training materials on this very subject. Next, a denial of accommodation. If the student believes in the end that the college is making an unjust decision of denial, then Disabled Student Services has the role of informing the student of their right to appeal and to file with OCR. So in the end, if the student believes that I need this accommodation, I deserve this accommodation, I don't think this accommodation fundamentally alters any kind of requirements or standard, I believe your decision is not right and you are violating my ADA or Section 504 civil rights, then the Disabled Student Services, or as some people call it, the Student Disability Access Office, they absolutely have an obligation to inform the student of their rights to appeal within the grievance system, the ADA grievance system within the higher education institution, and to inform them that they can file with the Office of Civil Rights at the U.S. Department of Education. Once again, to prevent irreparable harm, the college should have a procedure in place where the Disabled Student Services or the student is allowed to easily and quickly move up the ladder of authority in the appeal process. Now, notice what I said here is that I give a lot of technical assistance to higher education institutions. And what I do see, not uncommonly, is that the Student Disability Access Office is actually trying to do the right thing. They know the accommodations that should be occurring for the student. They've approached the department, they have approached the instructor. They're being told, nope, we are not going to do those accommodations. And so really the Student Disability Access Office should also have a way within the university system, within the college system, to appeal and to move up easily and quickly up the ladder in their appeal, where they can say, we believe we're right as the access office, and we believe these accommodations should be in place for this student. And so let's move up through the appeal process. Also, obviously, the student, as I talked about earlier, should have the ability to move up in their grievance appeal process quickly, so the college prevents irreparable harm. Truly having this type of procedure can help to reduce formal grievance filings with the Office of Civil Rights. Next. Discrimination complaints. If the student believes they have been discriminated against on the basis of disability, the student can go through the college grievance procedure, both formal and informal process. The student should be prepared to present their case. If they are dissatisfied with the outcome of the college's grievance procedures or want an alternative, they can file directly with OCE or file directly in court. So let me be clear here. A student does not have to. They are not required to participate in the college's, the university's grievance procedure. It may be a good idea to do so. Solving problems at the local level can be efficient, and if the college's grievance process does what it's supposed to do, it's helpful to all parties involved. but the student does not have to utilize the college grievance procedure. They can go directly and file with the U.S. Department of Education's Office of Civil Rights, or they can directly file in court, which generally means they go and find a private lawyer. As you can see on the slide, this is where you can file an OCR complaint. I think, because again, this is video, it's easy to go to ed.gov/OCR and simply in the search say OCR complaint process. OCR actually does provide technical assistance upon request. That's a good thing. Next. All right, let's look at resources. Next. The national network, we already talked about, the Southwest ADA Center. As you all know, we're one of 10 regional centers throughout the United States. We serve New Mexico, Texas, Arkansas, Louisiana, and Oklahoma. If you don't live in one of those states, you do have an ADA center. Just go to adata.org to find your center, or call the 800 number of 800-949-4232. Next. Last but certainly not least, there's an institution called AHEAD, Association on Higher Education and Disability. Their website is easy. It's simply ahead.org. AHEAD offers really an unparalleled member experience for those who have anything to do with, who are invested in creating a welcoming higher education experience for individuals with disabilities. They have been around a very long time. They actually even have international membership. They're all about making higher education accessible to students with all kinds of disabilities. They foster community and membership networking. They inform members of emerging issues relevant to disability in higher education. They watch legislative and regulatory spheres. They disseminate data and research, evidence-based practices, which I just usually say best practices. You'll find that most student disability access offices from higher ed are actually AHEAD members. And just keep in mind that they have many membership options. So they don't just have a membership just for student disability access offices. They have memberships for students, for interested parties. Their membership for a student is actually very affordable. I think they are well worth checking out. I think they're well worth becoming a member if you are involved in higher education, whether you're an instructor, whether you're a department head, whether you're student disability access office, whether you're a parent, whether you're an advocate. This is a resource you want to know about and certainly have full access to. All right. I hope that you found this session helpful. I want to thank Marissa DeMaya again, the Southwest ADA Center's Deputy Director, for making this recording possible. I'm Julie Ballinger, Southwest ADA Center affiliate. This ends the training. Thank you for joining us.